The rule of law is fundamental to democracy, and without the independence of judges and prosecutors, there cannot be a rule of law. Even during the apartheid years, the South African judges were independent, and some of them who were against all forms of racial discrimination were able to use their independence to find loopholes in statutes and laws and rule in favor of equality and against racial discrimination even in those years. I was often asked whether it was necessary to make compromises between peace and justice. And my firm view was then, and certainly strongly remains, is that without peace there cannot be justice, and there cannot be any moral reason to make compromises between them. It is also relevant with regard to the International Criminal Court in Africa to refer to the allegations of bias that there were starting about a decade ago, suggesting that the ICC, the International Criminal Court, was biased against Africa. It was a perception more than a reality, because most of the cases that came from Africa were referred to the International Criminal Court by the governments themselves. In any event, in recent years, the International Criminal Court has opened cases against a number of countries that are very remote from the African continent. It is important too for all countries, not only members of the Rome Statute, to domesticate international crimes. It's important to protect themselves from, if they wish to protect themselves from the jurisdiction of the International Criminal Court. If domestic prosecutions are brought against suspects before the International Criminal Court, if they are investigated and prosecuted in good faith in their home countries, that under the Rome Statute would rob the court of its jurisdiction. This applies, as I say, not only to members of the Rome Statute, but also to non-members. Take the United States of America. If the United States of America investigates crimes and prosecutes nationals of the United States for crimes for which are being investigated by the International Criminal Court, a good faith investigation in the United States would also rob the International Criminal Court of jurisdiction. Turning more specifically to Africa, one of the complaints against the International Criminal Court, and I should say this is not only an African complaint, has been inefficiency. This inefficiency has resulted at the end of 2000 in the setting up of the Independent Expert Review Committee. It was set up by the Assembly of States Parties under the Rome Statute to investigate and review the whole of the International Criminal Court and the Rome Statute system. It was my privilege to chair that committee of 9 experts, and we brought out a report at the end towards the end of last year, in which we made almost 400 recommendations for improvement of the processes and procedures of the ICC. I'm delighted to say that many of those recommendations have already been implemented. A number of others are being investigated, and I'm optimistic that they will be implemented in the coming years. The need for the ICC in Africa is really driven by the unfortunately large number of civil wars that have taken and are still taking place on our continent. As long as there are wars, there are going to be war crimes. And as long as there are war crimes, there is a need for an international criminal court. I wish I could optimistically say that the need for the ICC in Africa will go down in the coming years, but I think that would be wishful thinking. So with a more efficient court, it is my strong view that the African continent should welcome and embrace the International Criminal Court and use it to bring about justice for its own people.